Now I am going to dictate a legal passage based on latest judgment of the Kolkata High Court at the rate of 120 words per minute. Let's start. Thereafter, the appellant led the police to the house of his grandfather Ram Chandra Rao Chavan within bracket PW20 and produced one 12-bore DBBL gun, 2 empty cartridges, 1 live cartridge, 1 torch, Hero Honda motorcycle and 1 empty handbag, which were all seized. The appellant then led the police to the sugarcane field from where the left chapel of the deceased was recovered. He then led the investigation officer and the punches near Belanki Saravu within bracket backwater falls and shot the spot where he had shot the deceased dead pair. Thereafter, the appellant led the police to Srigiri complex at Diluk Nagar, Hyderabad, where he pointed out an electronic shop of S. Samba Kumar within bracket PW25 to whom he had sold the mobile phone. According to the prosecution, the shop owner identified the appellant and admitted the transaction and handed over the mobile phone along with a Xerox copy of the driving license of the appellant, which was kept as proof of address given by the appellant to the shopkeeper, which were seized by the police para. During the trial, the prosecution sought to prove the case against the appellant by examining as many as 31 witnesses and exhibited a number of documents and articles as mentioned above. The appellant took the plea of total denial. The appellant also did not lend any evidence in his defense para. The trial court, fast track court 2 and additional sessions judge Belagam in sessions case number 267/2006, after hearing the prosecution and defense and on consideration of the materials produced before it, convicted the appellant under sections 302 and 404 of the IPC and sections 3 and 5 punishable under section 25 and 27 of the Arms Act. Accordingly, upon being convicted under section 302 of the IPC, the court sentenced him to undergo rigorous imprisonment for life and to pay a fine of rupees 1,000 and in default of payment to undergo rigorous imprisonment for 6 months para. The appellant was also sentenced to undergo rigorous imprisonment for 1 year to pay a fine of rupees 1,000 and in default of payment of fine to undergo rigorous imprisonment of 3 months for the offence under section 404 IPC. Furthermore, the appellant was sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 500 within bracket rupees 500 and in default of payment of fine to undergo rigorous imprisonment for 3 months for contravention of section 3 punishable under section 25 of the Arms Act para. The appellant was also sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 1,000 within bracket rupees 1,000 and in default of payment of fine to undergo rigorous imprisonment for 3 months for contravention of section 5 punishable under section 27 of the Arms Act. All these sentences were directed to run concurrently para. Being aggrieved by the conviction by the additional sessions judge Belagam as above, the appellant preferred an appeal before the Karnataka High Court Circle Bench at Dharwad by filing criminal appeal number 666/2007. The said appeal was dismissed by the impugned order dated 06/12/2010, against which the appellant has preferred this appeal before us. Since the conviction by the trial court was affirmed by the High Court, it may be appropriate first to examine the basis on which the trial court convicted the appellant and how it was upheld by the court upheld it para. As can be seen from the narration of the incident by the prosecution, the case is based on circumstantial evidence as no eyewitness had seen the shooting of the deceased by the appellant with a gun which led to his death. Stop. Thank you.